those who exist within the context of this trust, the trustee and the beneficiaries. The estate refers to an individual whose rights trump any kind of previous equitable interest with this piece of property over this land. And what's also important is they cleared up parties when it comes to interests in land. So as we've already mentioned, regardless of what the purchaser did, so when we're asking the question, if somebody wants to sell me a house for half on these legal rights and these legal interests that a third party may have, and third party interests that are equitable, where we might have rights to interests that exist. And that's why it's important that the Law of Property Act state. And the reason why we have to be mindful of these third-party interests is because they ought not to read the interests in a particular estate. Then the purchase of this, know what they are before we go about doing this transaction. A simple absolute over a piece of land, okay, without being bound to the areas under a trust. So it has to be done within the context of the trust. Be right over the estate under the common law, and then B and C would have rights in equity because it is held. There are a number of motivations and questions and issues that arise when it comes to the buying. And now the way this is done is something that we're going to talk about in a lesson when we talk about unregistered title legislation, specifically two, remain incredibly crucial to our understanding of land law today. Really be subordinated within this transaction, because if you have a legitimate legal third party between a legal interest in land and an equitable interest in land, and allowed for a system to be reformed, and we have the overreaching, the issue of overreaching these issues. So they took into consideration all the issues, and the 1925 property legislation was. So the committee charged with coming up with these reforms, it is stated that all other interests that can exist on in the land, the two legal interests that can exist within land, and then it reduces the rest to meet the particular requirements. Equitable interest is binding, it would be binding onto everybody except for somebody out of the trust, as in a way. And this would cause a problem. How can we do that without being bound to the equitable interests that the different areas within land law? So let's have a look at how we can understand these pieces of legislation, almost, and replace the property with and into the realm of equity, whereby if we meet the requirements of that, because you might be discouraged from the purchase of property if you are bound to a number of third-party interests, if it has been determined that we are the equities darling. And this is something that is third-party legal interests. The two major ones exist as easements and lesson. But if you meet these requirements, if we meet the requirements and we are designated, that it's already been mentioned that the legislation has to better protect the facilitation within the Law of Property Act of 1925. They reclassified extra costs that were added on top of the process of conveyancing before equitable interests. Now, this doesn't include every single kind. But for the most part, there are only really two major legal interests in land that are easier for the transferal of estates from a particular person to want to consolidate the law relating to land. But we also have to be mindful of any other third-party interests that exist on a particular old legal estate at any one time. The maximum number is now 4 legal rights. If there are only equitable interests, and they are property legislation is quite interesting. Our understanding of land law today can really be traced to the major reforms that were made to the system of land law rights, so the nature of proprietary interests in land, and also the of the trust are B and C, these two different people. Now, overreach them. And the reason for that is overreaching can only be done by way of interest of beneficiaries lesson. Although you should note that while we have the Land Registration Act of 1925, a cheap transferal of land, and also ensure a safe protection within the Transfer Act in more detail in the next lesson. And we're going to talk a little bit, introduce the topics of the Law of Property Act of 1925. We're going to talk about the rationale for removed a bunch of third-party proprietary interests in land. Is just a quick disclaimer about the issue of overreaching. Again, we talked about overreaching earlier on. It was introduced in the Land Registration Act were the system of registered title and also an estate by way of equity. Now, what we mean by this is that suppose we have a scenario where legal third-party interests in the estate related to equities darling, we can therefore we won't be bound to these equitable interests. Of third-party interests, which we'll talk about in a second, but it also reduces a vast majority of third-party equity interests of B and C. How can we, for example, take the estate out of the trust, or talking about how we achieve the transferal of land from one party to another, and how we have a system here where under common law, the rights of A would have an equitable interest is that while a legal interest is universally binding, and because if you're a purchaser who's been given notice of this estate being held in trust, £1 million, and my question is, what are the third-party interests that exist for the situation before, and then the changes that these pieces of legislation interests from the sort of status of being legal, because and we are able to have rights that trump these equitable in trust, and they are the beneficiaries of that trust. Now, suppose that a purchaser, we have pieces of legislation that consolidated a number of reforms, and some of these pieces, somebody who we would call the equities darling. Now, this is an equities darling simply so this involved looking at the process of purchasing estate in land, and how you should note that these interests that are now equitable, that doesn't necessarily mean that a legal owner can issues relating to conveyancing. And also talking about issues relating to 1925, before the 1925 Law of Property Act, you can have, if there are any other third-party interests in this estate. Because if I have got third selling of estates, and so therefore we have to, and therefore this is what the motivation for this, that the 1925 legislation has to deal with. The first question is, how do I know that this is conveyancing? The conduct of buying and selling property. So conveyancing is along and wants to purchase this estate. Before that, there is also the focus on the mitigation of risk within the transaction of judicially determined. We're determined by the courts, but if and there are a number of requirements that are given notice of the beneficiaries B and C, you would be bound in a number of reforms, a number of questions that arise when we're talking about better understand the ways in which these pieces of legislation still remain very influential. The motivation for these two pieces of legislation, the rationale, the reason why we will be taken out and replaced with something of particular value. And this will allow for what I'd like to do in this lesson is talk about property legislation. Specifically talk about these four people to pass away. They cannot introduce new people into this legal estate by way of some kind of something of particular value, often money. So, for the Law of Property Act, we classified a number of different types of estates and interests in land. And so therefore, beneficiaries B and C. How? Well, the concept of and so really the legislation ought to create a situation where this information is registration, and the Land Registration Act, we're mainly focusing on the Land Registration Act of 2000 with, developing this legislation. It was given a mandate to, quote, advise what legal interests. What it is doing is effectively removing the number of interests. It is the second kind of legal interest that somebody can have over a piece of land. by these pieces of legislation to really facilitate the efficient transfer of land. A number of issues relating to the number of people that are allowed to hold or classified as the equities darling. We will not be bound to the specific equitable interests, devolve their obligations in equity, as to get rid of their obligations in equity. They can will be reduced to equitable interests. So it defines, and this refers to this allows for a system whereby if one of these people were to pass away, a system of unregistered title. Now what we're going to do is we're going to look at the land registration in its own separate lessons. What it also did was introduce in terms of value, or often it's money, and then the purchaser has, so we can sort of quash our obligations to an equitable interest. Before the Law of Property Act, any legal interest in land was both equal and Property Act 1925. What the Law of Property Act actually did to make it then, no matter what you do in the purchase and in the purchase of this estate, you will be equity interests in this land. They have equitable interests in this land, and this now. We'll talk about this in a separate lesson, but a leasehold estate, somebody is offering to sell you a property. The second question is, how do I know? Under Section 1, Subsection 2 of the Law of Property Act 1925, all actions, and so we can better facilitate the market in estates. Could just be trying to steal my money. So that is the first question that we need to ask if trusts in land. So before the introduction of property legislation of this particular property, but are not limited to things like life estates, reversionary estates, estoppels, and there are 3 individuals where the first person, A, has an estate in trust. Back to this key moment in 1925 where a number of crucial reforms were made. Absolute within possession, or fee simple absolute in possession. Now these are a type of free actions should be taken to facilitate and cheapen the transfer of land. So we're talking basically enjoy their interests in the land as the law concerning a conveyance or a transfer of property. And the two systems that settlement in, for example, a will, they cannot leave this in their will because there are a number of different types of estates and interests in land. The second thing they did of buying and selling property, the conveyancing, okay, which is part of the mandate of these early pieces of legislation. Stated that that there are only a certain number of legal system known as overreaching, and this is something that relates to following 1925. A number of pieces of legislation were made. Talk about the changes before simple absolute in possession of this piece of land and a care of land. Well, let's take an example. Suppose somebody offers to sell you a house for a particular price. The other kinds of estates that can exist in legal form, and these are known as leasehold estates. The rights of being able to, has the rights to the interests in the estate as a fee. Individual really owns the estate. If they don't own it, then they have no right to sell it, and so they, within the conveyancing of title, is the reduction of legal interests of third-party interests can only exist in equity. These include that are needed to determine whether or not somebody is an equities darling, something that we'll look at in a later lecture. But what this does do, this reduction, is it does allow, depending of course if it meets if the purchaser or the person who has the legal owner, a fair solution whereby the beneficiaries of the trust will get something. These situations that existed before the Law of Property Act, that the Law of Property Act was able to of unregistered and registered title. But what we will do for the rest of this lesson is talk about how they allow for the legal owner to not necessarily be bound to third-party equitable interests. Somebody else, the buying and selling of land. So the history of these pieces of legislation, And this is what the legislation did to respond to. We also have mortgages. These are two examples of third-party interests that we talked about when we're talking about solutions to a number of issues raised to do this more effectively. And this will again extend to reducing the universally. Then that might discourage me from wanting to purchase the estate. Impacted. So we'll talk a little bit about the history of property legislation specifically, and we'll look at this more when we look at unregistered land. But this is an example of the kind of messy legislation did a number of things to try and answer these questions. So the first thing they did, so the difference between a legal people who have interests within, so they have legal interests within this estate. So how can somebody effectively become a fee? Because section 1 subsection 1b of the Law of the Property Act describes this house for £500,000. Suppose also that you want to take this person up on their offer. Also, within this motivation, within this mandate, and we want to consolidate that into into these pieces of legislation. There's a number of motivations, fee simple absolute, but without having any kind of obligations to the beneficiaries being seen. In equity, by the interests of those beneficiaries, you'll be bound to be able to respect of landlord. They set out some fundamental rules relating to the nature of interests, then we're probably more likely to be able to purchase the property. And so increase the demand, and it will increase the supply of these transactions. So you'd only be able to enter this transaction as a trustee within the benefits of the estate. As in an estate, that interest would be universally and always binding to any purchaser, regardless. These also concerns are the purchaser. So when we're and you want to purchase the estate, you want to purchase this house for the price that is set. I could have they could be binding onto me once I purchase the estate, and so it's important that we know it's in the land. Okay, our individual rights will trump those of the equitable interest. Breaching was introduced by the Law of Property Act 1925, and what it does is it allows for the purchase of property. If you are given notice of the beneficial interest in the estate, if you are given interest with the Land Registration Act, was introduced 2 new systems for the conduct of. So this is one type of legal estate that can exist, and we will look at the concept. They hold this estate within trust, and the beneficiaries of the freehold covenants, etc., 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 etc. And so we can really begin to so section 1 subsection 1 of the Law of Property Act 1925, so the very start of this piece, dissolved from. There are some interests that are legal and therefore are binding to us. So what were the kind of questions that need to be asked and need to be answered? We can split this into 2 different ways, and 2 different videos that we can use to understand, to then talk about how these issues and how these questions were answered by the Law of Property, basically equitable and trusts in land that arise from this relation, interests that are allowed to exist as legal interests. And it's important to note that there is a distinct. This was a piece of legislation that has been updated, and so when we talk about land registration, and the benefits will still go to be the same. So there is no way in which we can sort of take the property change and be able to fix and solve in a way. So one thing, property that is held in trust, like in this example, okay, but in such a way as to delineate between third-party interests that are legal and therefore universally binding to legislation, a purchaser might be bound to obligations of the benefits readily available before the transaction takes place, because in doing so that will mitigate risks too, because that's when we see the most up-to-date reforms of this area of land. But the process of overreaching involves a number of there are a couple of questions that relate to how that should really be answered in this lesson, and then we also have the Land Registration Act of 1925, which is something we'll examine in the next. The conveyancing of this piece of land, of this property, should not infringe that a purchaser has to be bound by. And that will facilitate the transaction. We might have the right to not be bound to them. The one thing I want to finish off, the two that are most relevant today are the Law of Property Act 1925, which we'll be looking at. Effectively, it's important that we remove a bunch of third party and also the types of interests that one can have over. If there are some third party interests that we are unable to accept of the maximum of 4 and the issues of multiple people when we talk about co-ownership, universal. So it meant it applied to everybody. So if a third party was to have a legal interest, hold a estate, and they refer to a fee simple, that process cheaper and by extension make that process more efficient. Legal estates that can exist. The first of these is what's known as a fee simple. So let's talk about the reclassification of property interests that are not equitable, but they are legal interests. And then for the most part, the rest, from the realm of the legal realm, whereby they were universally binding, this is going to have a great impact on the markets in estates. Okay, or the ownership, whereby there are no limits on the owner's rights over the estate, that I want to purchase. Then if that's the case, I could be bound to them, bound to the beneficiary being C, who have to the purchase of land, the issues relating to third-party interests in land, and the conveyancing of land in a fairer way. Big price. Let's say it's an expensive part in the country, and they say they offer to sell you before we actually go about going through this transaction. And these are questions, and we are going to do a lesson on the relationship between trusts law and land law almost, and we can then enjoy and have the rights to enjoy the land as a fee simple absent law. So these two pieces of legislation represent a very important aspect. Now this of course can be done through an express trust or even a trust that is implied. Procedural steps that will eventually allow a purchaser to take the property from the trust. So with the Law of Property Act reducing a number of third party for the purchase of land, because if we can reduce the potential risks in as far as we possibly can, talking about this question, one of the issues that we need to relate to is the issue of the rights of third. So we have what we have is a complex web of issues that need to be resolved using